Good morning, dear students. Um, Today we'll be discussing the Contract Labor Regulation and Abolition Act 1970, which is in under Unit 4. Basically, the system of employment of contract labor, it is a universal phenomenon, and it prevails in various parts of our country, and especially in unorganized sector, which is its major constituent. And no doubt the system is efficient and economical. From the point of view of the employer, it is, however, exploitative in nature. In spite of many malpractices from which the system suffers, it is inevitable in timings of emergencies like floods, famines, earthquakes, wars, and now in like in pandemic and all that, when gigantic relief measures have to be undertaken. And in industry also, some jobs are purely temporary in nature. So the employment of contract or casual labor cannot be completely uh, ruled out. Under the circumstances of the government committed as it is to the ideal of social justice, and so it could not only apply the middle course, that is regulating the employment of contract labor in certain establishments and abolishing it in the certain other establishments. So the statement of objects and reasons appended in Contract Labor Regulation and Abolition Bill 1967, it also chartered its um, middle course, that the system should be abolished whenever possible, and practicable, and that in case the system could not be abolished altogether, and the working conditions of the contract labor should be regulated so as to ensure payment of wages and provision of essential um, amenities. And in this act, although it came into existence in 1967 and was passed in 1970 with the and it came into enforcement in 1971. So basically, the object of contract labor Regulation and Abolition Act 1970 is to prevent exploitation of contract labor and also to introduce better work conditions of work. A workman is deemed to be employed as contract labor when he is hired in connection with the work of an establishment by or through a contractor. Contract workmen are indirect employees, and contract labor differs from direct labor in terms of employment relationship with the establishment and method of wage payment. Contract labor, by and large, is not borne on payroll and nor is paid directly, but the contract workmen are hired, supervised, and remunerated by the contractor, who in turn is remunerated by the establishment who is hiring the services of the contractor. So that means it is basically both parties are accountable, contractor as well as employer. So the coverage, the act extends to the whole of India, and it applies to every establishment in which 20 or more employees are employed or were employed during the preceding 12 months as contract labor. Then every contractor employing 20 or more workers during the preceding 12 months. Appropriate government body may apply the provisions of this act to any establishment or contractor employing such number of employees less than 20 workers. Um, and as may be specified in the notification. But before it does that, it shall give at least 2 months notice of its intention to do so uh, by notification in the official gazette. So basically, it is how it is its coverage is being discussed, and this act basically governs with the registration and licensing. That means how a contractor should get registered, and how a contractor should apply for license so that he can have contractual workers, and similarly employer also as to how he should get registered for the say having contractual laborers. So first is appointment of registering officers. Under section C of the chapter 3rd of this act, the appropriate government may by an order notified in official gazette appoint registering officers for the purpose of for the purposes of the same. The registering officers shall be gazetted officers of the government, and the appropriate government may also define the limits within which a registering officer shall exercise the powers conferred on him or by the act. Then is registration of certain establishments. Well, every principal employer of an establishment to which the Act applies shall make an application to the registering officer in the prescribed manner for registration of the establishment. The application shall be made within such period as the appropriate government may by notification in the official gazette fix in this behalf with respect to establishment generally or with respect to any class of them. The registering officer may entertain any such application for registration after expiry of the period of fixed, whatever has been fixed in this behalf. And if he is satisfied that the applicant was prevented by sufficient cause from making the application in time. Then certificate of registration. If the application for registration is complete in all respects, the registering officer shall register the establishment and issue to the principal employer of the establishment a certificate of registration containing such particulars as may be prescribed. So, when you have to apply for the registration, so there is a procedure for making application for registration of establishment. First, the application referred to in subsection 1 of section 7 has to be made in triplicate in form 1 to the registering officer of the area in which the establishment sought to is to be registered and is located. The application referred to in sub rule 1 shall be accompanied by 2 demand draft showing payment of the fee for the registration of the establishment. That means whosoever is applying for the registration with the registering officer, he has to submit the demand draft as the fee. And every application referred to in sub rule 1 shall be either personally delivered to the registering officer or should be sent to him by registered post. Then on receipt of the application referred to in sub rule 1, the registration officer shall, after noting there on the date of receipt by him of the application, he will grant an acknowledgement to the applicant. Talking about the that how it goes for the registration and the licensing. Then there is revocation of registration in certain cases. So if the registering officer is satisfied either on a reference made to him in his behalf or otherwise, he may be the he may with the previous approval of the appropriate government revoke the registration on any establishment. Under what circumstances? First, if the registration has been obtained by misrepresentation or suppression of any material fact, or if for any other reason the registration has become useless or ineffective and therefore requires to be revoked. Before revoking the registration, the registering officer shall give an opportunity to the principal employer for the establishment to be heard. Then we have effect of non-registration. An establishment to which this act applies is required to be registered under section 7. If such an establishment has not been registered with the time fixed for the purpose, the principal employer shall not employ contract labor in the establishment after the expiry of the period fixed. That means if you are not having, if an establishment who is supposed to take the who's supposed to get the registration. If it is not registered, then establishment cannot have the contractual labor. Then there are certain prohibitions also, prohibition of employment of contract labor. Appropriate government, they may prohibit by notification in the official gazette employment of contract labor in any process, operation or other work in any establishment. However, before doing so, it shall consult the central board, or obviously as the case may be, if it is a state board. And before issuing any notification under Section 10 in relation to an establishment, the appropriate government shall have regard to the conditions of the work and benefits provided for the contract labor in that establishment, and other relevant factors, such as process, whether it is what is the nature of the work, and is it done ordinarily through regular employees in that establishment or an establishment similar thereto. So whether it is sufficient to employ considerable number of whole-time employees and all that. So there are guidelines based upon this, which was given by the Supreme Court. So those guidelines have to be followed by the employer or the establishment. Then talking about that, there are certain requirements or the checklist for principal employer. That first is that what all it should keep into mind before applying for registration. So registration of establishment, displaying of following notices of wages, hours of work, wage period, date of payment of wages, date of payment of unpaid wages, name and address of inspector having jurisdiction, then maintenance and preservation of register of contractor. That means all whatever is being given, and whatever are the documents and wages which are being given to the say contractor, or what the number about the number of the contractual laborers whosoever are working in the establishment. They have to be recorded and documented in a register, and that register has to be maintained and preserved. Filing of return of commencement and completion of the contract, then filing of annual return, supervising the responsibilities of contractor to avoid enjoying the liabilities. Then ensure provision of facilities of canteen, drinking water, washing and restrooms, latrines and urinals, first aid, creche, and they are provided by the contractors. Then there are certain requirement and checklists for contractor as well. So these requirements, they are for obtaining registration by the principal employer. Then now this is the license which is to be obtained by the contractor. So first is licensing, obviously. Then renewal of the license. License has to be updated. Maintenance and preservation of register of persons employed, master rolls, register of wages, register of fines, register of deduction, damages, advances, and overtime. Then display of notice, rate of wages, hours of work, wage period, date of payment of wages, date of payment of unpaid wages, name and address of the inspector having jurisdiction. That has to be written down in a local language and displayed in the through notices. Then even contractor is supposed to provide facilities of canteen, drinking water, washing, restroom, latrines and urinals, first aid and creche. Then employee card has to be generated by the contractor and given to the contractual workers. Then service certificates and half yearly return. So principal employer is supposed to file of annual return, and contractor is supposed to file in the half yearly return. Then when we talked about say registration and licensing, this the act basically it applies to the principal employer of an establishment and contractor, as we already discussed, wherein 20 or more workers are working. So if a principal employer or the contractor falls within the vicinity of this act, such principal employer and the contractor have to apply for registration of the establishment and license respectively. The act also provides for temporary registration. in case the contract labor is hired for a period not more than 15 days. Any change occurring in the particulars specified in the registration or licensing certificate needs to be informed to the concerned registering officer within 30 days of such change. So, from combined reading of Section 7 and Rules 17 and 18 of contract labor, it appears that the principal employer has to apply for registration in respect of each establishment. That means if he is running more than one or two establishments, he has to apply for registration for each establishment. Other important point is to note down is that license issued for one contract cannot be used for entirely different contract work, even though there is no change in establishment. That means if there are two different works that have been outsourced to the contractor, so contractor needs to have two different licenses. It doesn't matter if the establishment is same. Then there are certain penal provisions as well. Section 9 of the Act provides that the principal employer to whom this Act is applicable, if he fails to get registered under the Act, then such principal employer cannot employ contract labor. It also appears that if the establishment is not registered or if the contractor is not licensed, then the contract labor shall be deemed to be the direct workman, and the principal employer or establishment shall be liable for wages. And that means in that case, contractor shall not be held responsible. It would be the principal employer. Uh, then the Act enjoins joint and several responsibility of principal employer and the contractor. Principal employer should ensure that the contractor does the following. That means it becomes the responsibility of employer to ensure that the contractor pays the wages as determined by the government, pays the wages as may be fixed by the Commissioner of Labor, or in the absence pays fair wages to the contract labor. And obviously he has to provide the facilities which we already listed upon. Then there is registering and licensing, as we already discussed that how to obtain registration or how to get registered your how establishment or how principal employer can get registration. Then similarly it goes for the licensing, that how contractor he will he is supposed to get the license. So first is um, when like if a contractor is applying for the license, um, they have to contractor has to show certain things against which he can be given license. First is hours of work, fixation of wages, and other essential amenities, but we already discussed in the checklist. For the contractor, he has to provide all that. Then every application, then he has to apply for the application for the grant of license to undertake or execute any work through contract labor. It shall be made in the prescribed format and should contain the particulars regarding regarding it. Then there has to be investigation by the licensing officer. Licensing officer may make an investigation in respect of the application for grant of license, and in making any such investigation, the licensing officer shall follow procedure which is prescribed by the as per the act and as prescribed by the government. Then validity and renewal of the license. License which is granted for undertaking or executing any work through contract labor um, shall be valid for the period of whatever has been specified, whatever has been specified therein. It may be renewed from time to time for such period or any payment mm, of such fees and on such conditions that may be prescribed. Then there could be there may be say certain conditions wherein uh, a person, a registration officer or the licensing officer, he may refuse or suspend the license. So, if the licensing officer is satisfied either on a reference made to him on his behalf or otherwise, he may revoke or suspend a license for undertaking or execute any work through contract labor. So, and when he can suspend that license, if the license granted under section 12 has been obtained by misrepresentation or suppression of any material, or the holder of license has without reasonable cause failed to comply with the conditions subject to which the license has been granted, or has contravened any of the provisions of this act or the rules made thereunder. So, in all the above cases, the licensing officer may also forfeit the sum, if any, or any portion there is deposited as security for the due performance or the condition of um, which is subjected to which the license has been granted. He shall, however, give the holder of the license an opportunity to show cause. That means, if even license, even if the contractor is not satisfied with with the reasons that has been justified by the licensing officer for refusal of say license, then he is given a chance where licensing officer is putting down certain cases, certain conditions for which he has been reduced, for which he has been refused to grant the license. So he may ask for the show cause. So then so this was so talking about this, the requirements and then so application of license, which we all already discussed, that every application by a contractor for the grant of license has to be made in triplicate in form 4 to the licensing officer of the area in which the establishment in relation to which the he is the contractor. Then as we said, that application for the grant of license has to be accompanied by the certificate by principal employer in form 5 to the effect that the applicant has been employed by him as a contractor in relation to his establishment. So a license has to be delivered to the licensing officer, or either the contractor can present it personally, deliver it personally, or send to him by registered post. And on the receipt of application, as referred to in the sub rule 1, the licensing officer shall, after noting thereon the date of receipt of the application, grant an acknowledgement of the applicant. Every application referred in sub rule 1 shall be accompanied by a demand draft showing the deposit of the security at the rates specified in Rule 24, and second, the payment of the fees at the rate specified in sub Rule 20, specified in 2622. So this was all about say the Contract Regulation and Abolition Act 1970. Thank you.